in the court.
Question number 76. Which of the following provisions of the Indian Evidence Act was omitted by the Amendment Act of 2002? Options are Section 155 subsection 2, 155 subsection 3, 155 subsection 4 or 155 subsection 5. Correct answer is Section 155 subsection 4 of the Indian Evidence Act. Section 155 talks about impeaching credit of a witness, जो कि अब प्रोवाइडेड है सेक्शन 158 में ऑफ द भारतीय साक्ष्य अधिनियम. Question number 77. Which of the following sections of the Code of Criminal Procedure defines the term judicial proceeding? Options are Section 2 subsection I, 2J, 2K or 2L. Correct answer is Section 2 subsection I. Option A is the right answer. और अब ये कहाँ प्रोवाइडेड है? इट इज़ प्रोवाइडेड इन सेक्शन 2 सबसेक्शन 1 क्लॉज M of the BNSS. Question number 78. In which of the following cases the Supreme Court has issued specific guidelines regarding arrest? Vishakha versus State of Rajasthan, A.R. Antule's case, D.K. Basu's case or Nandini Satpathi's case? Correct answer is D.K. Basu's case. Option C is the right answer. D.K. Basu versus State of West Bengal. Question number 79. What is the maximum amount of maintenance which can be ordered by a magistrate as monthly allowance under Section 125 of the Code of Criminal Procedure? Options are rupees 1,000, 500, 2,000 or no limit. There is no limit. Section 125 of the CRPC is now Section 144 of the BNSS, भारतीय नागरिक सुरक्षा संहिता. Question number 80. Under Section 164A of the CRPC, the victim of rape shall be sent to the registered medical practitioner for examination within dash hours from the time of receiving information relating to the commission of such offence. 6 hours, 12 hours, 24 hours or 36 hours. It is 24 hours. Section 164A is now Section 184 of the BNSS. Question number 81. Which of the following subsections was or were inserted by the Code of Criminal Procedure Amendment Act of 2005 in Section 176 of the CRPC? Options are Section 176 subsection 1A, 176 subsection 1A and 1B, 176 subsection 5 and 6, 176 subsection 1A and 5. Correct answer है option D. Section 176 subsection 1A and subsection 5. Section 176 जो है CRPC का is now Section 196 of the BNSS and it is related to inquest. Question number 82. The period of limitation prescribed in the Code of Criminal Procedure is not applicable to the offences under the Income Tax Act, the Customs Act, the Foreign Exchange Management Act, or all of the above. Correct answer is all of the above. Option D is the right answer. Question number 83. The Code of Civil Procedure Amendment Acts of 1999 and 2002 were enacted on the recommendations of Santhanam Committee, Malimat Committee, Thakkar Committee or none of the above. Correct answer है Malimat Committee. Option B is the right answer. Question number 84. Which of the following landmark judgments of the Supreme Court deals with the applicability of res judicata in writ petitions? Options are Satyadhan Ghoshal versus Deorajan Devi, Daryao versus State of UP, LIC versus India Automobiles and Company or none of the above. Correct answer है Daryao versus State of UP. Option B is the right answer. Question number 85. A court can return the plaint when the court has got no territorial jurisdiction, no pecuniary jurisdiction, no subject matter jurisdiction or any of the above? Correct answer is any of the above. और रिटर्न ऑफ प्लेंट के बारे में कहाँ बात करी गई है? अंडर ऑर्डर 7 रूल 10 of the CPC. Question number 86. The Code of Civil Procedure Amendment Act of 2002 came into force on 1st of April 2002, 1st of June 2002, 6th of June 2002 or 1st of July 2002. Correct answer है 1st of July 2002. Option D is the right answer. Question number 87. The provision for setting aside the arbitral award is laid down under Section 32 of the related act, that is Arbitration and Conciliation Act, Section 36, Section 34 or none of the above. Correct answer is Section 34 of the Arbitration and Conciliation Act. Option C is the right answer. Question number 88. The parties to the arbitration agreement shall appoint arbitrator within 30 days, 60 days, 40 days or 90 days. Correct answer is 30 days. Question number 89. The decrees or orders made by small causes court are revisable by district court, high court, both A and B or none of the above. Correct answer है the high court. Option B is the right answer. कहाँ पे provided है? It is provided under section 25 of the Provincial Small Causes Courts Act. Question number 90. Who is authorized to abolish courts of small causes? The concerned high court, the concerned state government, the concerned district court or the concerned district court after consultation with the concerned high court and the state government. Correct answer है the concerned state government. Option B is the right answer. Question number 91. In which of the following cases it was contended that the preamble to our constitution should be the guiding star in its interpretation and hence any law made under Article 21 should be held as void if it offended against the principles of natural justice? Options are Gopalan versus State of Madras, Keshwananda Bharti versus State of Kerala, Bhim Singh versus Union of India or Excelware versus Union of India. Correct answer है A.K. Gopalan versus State of Madras. Option A is the right answer. Question number 92. Which of the following cases upheld secularism as a basic feature of the Indian Constitution even before the word secular was inserted in the preamble? Options are Indira Gandhi versus Raj Narayan, Keshwananda Bharti versus State of Kerala, Vaman Rao versus Union of India or Samatha versus State of Andhra Pradesh. Correct answer is Keshwananda Bharti versus State of Kerala. Option B is the right answer. Question number 93. In which of the following cases the consensus of the majority of the judgment was that the basic structure of the Indian Constitution could not be destroyed or damaged by amending the Constitution in exercise of the power under Article 368 of the Indian Constitution? Options are Vaman Rao versus Union of India, Golaknath versus State of Punjab, Kuldeep Nair versus Union of India or none of the above. Correct answer है Vaman Rao versus Union of India. Option A is the right answer. Question number 94. A person who or whose father was not born in the territory of India but who has his domicile in the territory of India and has been ordinarily residing within the territory of India for not less than 5 years immediately preceding the commencement of the Constitution is considered as Indian citizen. Which of the following articles of the Indian Constitution describes it? Article 5, 5B, 5A or 5C? Correct answer है Article 5C. D is the right answer. Question number 95. Clause 4 of Article 13 of the Indian Constitution, which was inserted by the 24th Amendment Act of 1971, states that a Constitution Amendment Act passed according to Article 368 of the Indian Constitution is a law within the meaning of Article 13 and would accordingly be void if it contravenes a fundamental right. This amendment was declared void in which of the following cases? Options are Golaknath versus State of Punjab, Edward Mills Company Limited versus State of Ajmer, Minerva Mills versus Union of India, और गुलाम सरवर versus Union of India. करेक्ट आंसर है मिनेर्वा मिल्स वर्सेस यूनियन ऑफ इंडिया. ऑप्शन सी इज द राइट आंसर. Question number 96. Which of the following is an essential part of rule of law and independence of judiciary? Judicial review, impartial appointment of judges, impeachment, original jurisdiction. Correct answer है judicial review. A is the right answer. Question number 97. The test of reasonableness is not a wholly dash test and its contours are fairly indicated by the Constitution. Subjective, objective, descriptive or summative. So the test of the reasonableness is not a wholly subjective test. Option A is the right answer. Question number 98. Taxation is a dash power of the state and there is no fundamental right to be immune from taxation. Options are it is an independent power, statutory power, authoritative power or administrative power. So it is an independent power. Option A is the right answer. Question number 99. Protection in respect of conviction for offences is the essence of which of the following articles of the Indian Constitution? Article 22, 21, 20 or 19. It is Article 20 of the Indian Constitution. Option C is the right answer. Question number 100. According to Clause 1 of Article 25 of the Indian Constitution, the freedom of religion is subject to the interest of public order, morality, health, all of the above. All of the above is the correct answer. So D सही option हो जाएगा. Question number 101. Which of the following articles of the Indian Constitution mentions the provision of the post of the Prime Minister in India? Options हैं Article 73, 74, 75 or 74 Clause 1. Correct answer is Article 75 of the Indian Constitution. Question number 102. A person shall be disqualified for being a member of either house of the parliament if he is so disqualified under the dash schedule. Options are 6th schedule, 8th, 7th or 10th schedule. Correct answer है 10th schedule. Question number 103. Judges of the Supreme Court can be removed from their office by impeachment, the President, the Council of Ministers or the House of People. Correct answer is the President on the ground of proved misbehavior and incapacity, and it is provided under Article 124 Clause 4 of the Indian Constitution. Impeachment से कौन remove किए जा सकते हैं? It is the President who can be removed by the process of impeachment. Question number 104. Which of the following has been held to be questions of fact and not of law? Options are whether a fact has been proved when evidence for and against has been properly received, whether a statutory presumption has been rebutted, whether an endowment is private or public, there being no questions of misconstruction of a document involved, or all of the above. So correct answer is all of the above because they all are questions of fact. Question number 105. The Chief Minister shall be appointed by the Prime Minister, Governor, President or Vidhan Sabha. Correct answer is by the Governor under Article 164 Clause 1 of the Indian Constitution. Question number 106. Absolutism means the state of being absolute, correct? A sort of government in which public power is vested in some person or persons, unchecked and uncontrolled by any law or institution. Option C. Unconditional power or sovereignty vested in a monarch, an autocrat or an oligarchy. All of the above is the right answer. D is the right answer. Question number 107. Mandamus is issued to check the performance of duties of a public nature. is issued to impede the performance of duties of a private nature, is issued to compel the performance of duties of a public nature, or none of the above. Correct answer है is issued to compel the performance of duties of a public nature. Option C is the right answer. It is mandamus is one kind of a writ, and the Supreme Court has the power to issue the writs under Article 32, और हाई कोर्ट के पास सिमिलर पावर होती है अंडर आर्टिकल 226 ऑफ द इंडियन कॉन्स्टिट्यूशन. Question number 108. Which among the following has the power to extend the functions of the State Public Service Commission? Options are the Governor, State Legislator, the Chief Minister, the Advocate General. Correct answer है the State Legislator or the Legislature. So option B is the right answer. अगर question में ऐसा होता, if the question would have been with regard to the Union Public Service Commission, तो सही आंसर होता the Parliament, because सेंटर में पार्लियामेंट है और स्टेट लेवल पे इट इज़ द स्टेट लेजिस्लेचर. Question number 109. While a proclamation of emergency is in operation, the executive power of the Union shall extend to the giving of directions to any state as to the manner in which the executive power thereof is to be exercised. This is correct. Then option 2 is the power of the Parliament to make the laws with respect to any matter shall include the power to make laws on the subject which is not enumerated in the Union list. This is also correct. अब पूछा क्या गया है, पूछा ये गया है कि which of the above statements are or is found to be correct. तो both the statements above are correct. तो हमारा सही आंसर हो जाएगा ऑप्शन सी, both 1 and 2. Question number 110. The governor must remain conscious of his constitutional obligations and not sacrifice either political responsibility or parliamentary conventions on the altar of political expediency. In which of the following cases the constitutional obligations of the governor were mentioned? Options are S.R. Chaudhary versus State of Punjab, B.R. Kapoor versus State of Tamil Nadu, Krishna Ballabh Sahai versus Commission of Inquiry, or none of the above. Correct answer है S.R. Chaudhary versus State of Punjab. Option A is the right answer. Question number 111. Administrative law is the law relating to the administration. It determines the organization, powers and duties of the administrative authorities. Who among the following jurists has given the definition, the above definition? Options are Ivor Jennings, Casey Davis, Owen Hood Phillips, or Keith. The right answer is Ivor Jennings. Option A is the right answer. Question number 112. State the similarity between the constitutional and the administrative laws. Options are both constitutional and administrative laws are private laws. Both constitutional and administrative laws regulate the highest norms of the state. Both constitutional and administrative laws deal with the organization and functions of the government at rest. Both constitutional and administrative laws are public laws. Yes, this one is right. Option D is the right answer. Both constitutional and administrative laws are public laws. Question number 113. The privilege to withhold the documents or information under the administrative law is enacted in which of the following sections of the Evidence Act? Options are section 120, 126, 123 or 98. Correct answer is section 123 of the Indian Evidence Act, which is now section 129 of the Bharatiya Sakshya Adhiniyam. Question number 114. According to Dicey, the meaning of the rule of law may be discussed under which of the following heads? Equality after law, equality of fixed rules of law, equality under law, or equality before law. So the right answer is equality before law. Option D is the right answer. Question number 115. Casey Davis, in his book Administrative Law, gave several meanings of the term rule of law. Choose the correct option accordingly. Options are fixed rules of law, exclusion of discretion, both A and B, or neither A nor B. Correct answer है both A and B. Option C is the right answer. Question number 116. The doctrine of separation of powers can be explained by which of the following? Options are same person should not form the part of more than one of the three organs of the government. Same person should not form the part of more than two of the three organs of the government. Or same person should not form the part of any organ of the three organs of the government. Or none of the above. The right answer is same person should not form part of more than one of the three organs of the government. Option A is the right answer. Question number 117. In modern states, the executive function is further classified as quasi-legislative, quasi-judicial, ministerial, and purely administrative functions. This observation is based on which of the following cases? Options are Hari Shankar Bagla versus State of MP, Menka Gandhi versus Union of India, Hamdard Dawakhana versus Union of India, or all of the above. Correct answer है Menka Gandhi versus Union of India. Option B is the right answer. Question number 118. Delegated legislation in India can be decided for the post-constitution period. This was held by Queen versus Bura, Ray Delhi Laws Act, J.N. Gupta versus Province of Bihar, both A and C. Correct answer है Ray Delhi Laws Act 1912. Option B is the right answer. Question number 119. Choose the function which cannot be delegated under the administrative law. Options are power to give retrospective effect, appointed day and commencement of the act, application of existing laws, or suspension of operation of all or any of the provisions of the act. Correct answer is option A, power to give retrospective effect. A is the right answer. Question number 120. What is the disadvantage in delegated legislations? In case of gross violation of rights of the people, delegated legislation can be withdrawn or amended suitably without much delay. No, this is not a disadvantage. Option B, there are chances to misuse the powers which are given by the Parent Act, and thereby the executive may enjoy more power than the parliament. Yes, this is right. This is one of the disadvantage of delegated legislation. So option B is the right answer. Question number 121. Conditional legislation under the administrative law is also known as subordinate legislation. While making legislation, the subordinate authorities can use their discretion. Also known as contingent legislation. No discretion can be enjoyed as there is no rule making power. Neither A nor B, or both A and B. Correct answer is conditional legislation is also known as contingent legislation. No discretion can be enjoyed as there is no rule making power. Option B is the right answer. Question number 122. The principle of natural justice is one procedural rule for the administrative action. Considering the above statement, which of the following is or are justified? No man should be judged in his own cause. All men should be judged in their own cause. All of the above, neither A nor B. Correct answer is no man should be judged in his own cause. Option A is the right answer. और ये जो है ये एक लीगल मैगजिन पे बेस्ड है नेमो जुडेक्स इन कॉजा सुआ. Next is question number 123. The courts in almost all the democratic countries enjoyed the power to decide the validity of the delegated legislation under the administrative law and apply the test. The above is related to which of the following? Options are test of substantive ultravires and test of procedural ultravires, or where the parent act itself is unconstitutional and delegated legislation is unconstitutional, neither A nor B, or both A and B. Correct answer is test of substantive ultrawires and test of procedural ultrawires. Option A is the right answer. Question number 124. The rule against bias can be discussed under the following heads: pecuniary bias, personal bias, bias as to subject matter. The personal bias is decided by the Supreme Court under which of the following cases? Options are Dimes versus Grand Junction Canal, Gullapalli Nageshwara Rao versus APS RTC, A.K. Kripak versus Union of India, or Manaklal versus Dr. Prem Chand. Correct answer is A.K. Kripak versus Union of India. It is a landmark case. Option C is the right answer. Question number 125. Habeas corpus literally means have the corpus or bring the body, under which case habeas corpus was not being issued. Options are A.K. Gopalan versus State of Madras, Batul Chandra versus State of West Bengal, both A and B, neither A nor B. Correct answer is Batul Chandra versus State of West Bengal. Option B is the right answer. Question number 126. The essential law for the alteram partem is issuance of notice without hearing? No. Taking adverse action against him? No. Depriving the rights? No. Notice? Yes. Notice is the right answer. Option D is the right answer. Question number 127. What is the essential condition of mandamus? The petitioner must have legal right which can be judicially enforceable. This is correct. Option B, the public authority concerned must do his duty. This is also correct. But इसमें the public authority must have a duty and at the same time the authority should have failed to do that statutory duty. तो ये incomplete है, therefore it is incorrect. Option C is the petitioner should not make a demand for the performance of the duty. This is also incorrect. None of the above. So option A is the right answer. Question number 128. According to the constitutional provisions regarding contractual liability of the state, which of the following conditions must be fulfilled in order to make a contract valid in which the government is a party? Options are the contract has to be executed on behalf of the president or the government as the case may be. Yes, this is right. Any executive entering the contract on his own? No. Any contract expressed to be made without any authority? This is also incorrect. All of the above. Correct answer therefore is option A. Question number 129. Tribunals deal with the service matter only. Choose the correct option among the following which is true for the above statement. Options are it is presided over by the judge or magistrate. It is wrong. Option B, CPC and rules of evidence must be followed. It is also wrong. Why? Because here it is written must be followed. Then option C is it is decided based on the rule of law, procedure and rule of evidence. This is also incorrect. None of the above. So option D is the right answer. Question number 130. What is the qualification of ombudsman? Options are Lokpal shall not hold any office of profit. This is correct. Lokpal shall be a member of parliament, not necessary. Lokpal shall carry on any business or profession, not necessary, none of the above. So A is the right answer. Option A is the right answer. Question number 131. Hindu law is a civil law, personal law, constitutional law or criminal law? Correct answer is it is a personal law of the Hindus. Option B is the right answer. Question number 132. The ancient sources of the Hindu law is or are Shruti, Smriti, Digest, Commentaries and Custom, or all of the above. The right answer is option D, all of the above. Question number 133. Section 5, subsection 1 of the Hindu Marriage Act 1955 provides for monogamy, bigamy, polygamy or polyandry. Correct answer है monogamy. Option A is the right answer because it prohibits bigamy. Question number 134. Under which section of the Hindu Marriage Act judicial separation has been provided? Options are section 9, 10, 11 or 13. Correct answer है section 10. Option B is the right answer. सेक्शन 9 में बात करी गई है रेस्टिट्यूशन ऑफ कॉन्जुगल राइट्स के बारे में. सेक्शन 11 टॉक्स अबाउट वॉइड मैरिजेस एंड सेक्शन 13 टॉक्स अबाउट डिवोर्स. क्वेश्चन नंबर 135. Section 16 of the Hindu Marriage Act deals with the legitimacy of the children of void marriages, voidable marriages, void and voidable marriages or valid marriages. Correct answer है void and voidable marriages. Option C is the right answer. And it says that the children born out of void or voidable marriages are legitimate children. Question number 136. A Hindu marriage may be solemnized according to the customary rites and ceremonies of bride, bridegroom, both the parties, or either party thereto. Correct answer is either party thereto. Option D is the right answer, and it is provided under Section 7 of the Hindu Marriage Act. Question number 137. Son in Class 1 of the Schedule of the Hindu Succession Act 1956 does not include adopted son, stepson, illegitimate son, or none of the above. Correct answer है it does not include a stepson. Option B is the right answer. Question number 138. Which of the following is correct under Section 10 of the Hindu Succession Act 1956 for the surviving sons, surviving daughters, and the mother of the male intestate? Options are each shall take one share, all will take one share, all the sons and daughters shall take one share and the mother shall take one share, or all the sons and daughters shall take one share and the mother shall take no share. Correct answer है each shall take one share. Option A is the right answer. And it is provided in Rule 1 of Section 10 of the Hindu Succession Act. Question number 139. Under Section 14 of the Hindu Succession Act, any property possessed by a female Hindu, whether acquired by her before or after the commencement of this act, shall be held by her as a full owner, limited owner, co-owner with her husband, or none of the above. Correct answer है as a full owner, because by virtue of Section 14, such female becomes absolute owner of the property. So option A is the right answer. Question number 140. According to the Hindu Adoption and Maintenance Act 1956, minor means a person who has not completed his or her age of 14 years, 16 years, 18 years or 21 years. Correct answer है 18 years. Option C is the right answer. And it is provided under Section 3 of the Hindu Adoptions and Maintenance Act. Question number 141. A female Hindu who is a major and is of a sound mind is capable to take in adoption a son or a daughter if she is a widow or divorced woman, she is unmarried woman, her husband has completely and finally renounced the world or has ceased to be a Hindu or has been declared by a court of competent jurisdiction to be of an unsound mind, all of the above. Correct answer है all of the above, and it is provided in Section 8 of the Hindu Adoptions and Maintenance Act. Question number 142. A junior male member of a Hindu undivided family may be its karta when he is able and intelligent, not required, without the consent of the gopasnas of the family if he is able and clever, no, only with the consent of the other gopasnas of the family. Yes, this is right. Only with the order of the mother. No, this is also incorrect. So हमारा सही आंसर हो जाएगा ऑप्शन सी. only with the consent of the other co-partners of the family. Question number 143. What are the main sources of the Muslim law? Options are Quran, Sunnat and Ahadith, Ijma and Qiyas, all of the above. So the answer is all of the above. Option D is the right answer. Question number 144. By which man a Muslim lady may legally marry? Hindu, Muslim, Kitabiya or none of the above? Correct answer is a Muslim. Option B is the right answer. Question number 145. With whom a Shia Muslim man is entitled to perform a muta marriage, that is a temporary marriage. Options are Muslim woman, Christian woman, Jewish or a fire worshipping woman, or any of the women stated above. Correct answer is any of the women stated above. Option D is the right answer. Question number 146. Whether a Muslim may give talaq in the state of intoxication or under pressure? Yes, recognized under the Sunni Muslim law, recognized under the Shia Muslim law, according to the Ismailia law, or according to the Usuli law. Correct answer is it is recognized under the Sunni Muslim law. Option A is the right answer. Question number 147. By the third pronouncement, utterance of talaq, which kind of talaq becomes effective? Options are talaq-e-hasan, talaq-e-ahsan, talaq-e-tafweez or none of the above. Correct answer है talaq-e-hasan. Option A is the right answer. Question number 148. Acknowledgement of paternity once made under the Muslim law cannot be revoked, can be revoked, can be revoked by previous permission of capable judiciary or none of the above. The answer is it cannot be revoked once it is made. So option A is the right answer. Question number 149. In whose custody the Muslim illegitimate children will be kept? Options are father, mother, both father and mother, maternal grandmother. The correct answer is option B, mother. Question number 150. Which of the following gifts is not valid? Options are gift in future, conditional gift, gift based on wagering contract or contingent contract, all of the above. Correct answer है all of the above. Option D is the right answer. इसी के साथ हमारा BJS 2016 का पेपर ख़त्म होता है. वीडियो अच्छा लगा हो तो चैनल को लाइक शेयर और सब्सक्राइब करो. सी यू इन द नेक्स्ट वीडियो. बाय बाय. टेक केयर.